Welcome everyone to our second speaker series session of 2022. My name is Caitlin Corrigan. I am the Executive Director of the Institute of Ethics and Artificial Intelligence. And I'm here today with Henrik Olsen and Thomas Hildebrandt for our virtual speaker series. With its speaker series, the TUM Institute for Ethics and Artificial Intelligence invites experts from all over the world to talk about ethics and governance of AI. These events serve as an important platform for sharing new research and exchanging knowledge. Since our launch in 2019, we are already able to run 20 speaker series events. Because of these virtual events in particular, we're able to reach an even broader audience from all around the globe, as we'll see today. From the audience, I can already tell. We are looking forward to hearing from you today during our discussion. We are delighted to have Professor Thomas Hildebrandt and Professor Henrik Olsen from the University of Copenhagen here with us today. They're going to talk to us today about AI and legal tech, an ethical perspective. Let me say a few words about each of our speakers. Professor Olsen is an international legal scholar, and a professor of jurisprudence at the University of Copenhagen Faculty of Law. As co-founder of the Center of Excellence for International Courts, I-Courts, he has contributed to the development of a foundational science research agenda in law and has pioneered research in a new field of computational law. He has also contributed actively to introducing computational law approaches in active litigation before Supreme Courts of Denmark. Professor Hildebrandt is a professor of software engineering and head of the research section for software data, people, and society. With a background in formal process models, he has been leading the interdisciplinary research and innovative projects with focus on methods and technologies for developing reliable and flexible software systems. We're excited to hear from them in just a minute, but before I begin, I would like to ask you all to keep your microphones and cameras off as you have been doing so far. Submit your questions via the chat function and we'll get to them as many as we can, or if you would like to speak directly, use the raise your hand function and we can unmute you when we have a moment to do so. We'll try to answer as many questions as possible, but also let us know in the chat throughout the presentation if you're having some sort of technical difficulty. It's always good for us to know. So with that, I hand it over to Professor Olsen and Professor Hildebrandt.
Thank you so much, Caitlin. I hope you can hear me.
Yeah.
I'm gonna try to share screen now so that everyone can see my presentation. Just go to presentation mode here. That's it. So is that fine, Caitlin? Yeah, it's very good. So thank you so much for this presentation. I'm very delighted to be able to give this presentation today with Thomas. Thomas and I, we've been working together for a couple of years on various projects. And the way that we have structured our presentation today is that first, I'm going to say a little bit about legal tech, how it works, and I will do that with the main focus on case law analysis. Case law analysis is something that's very important for legal practice. Often when you present arguments in a court of law, you refer to existing practices, sometimes referred to as precedent, but also in public administration, there's a lot of references to prior cases and prior decisions that are used as a basis for new decisions, so as to be able to keep a coherence in the administrative agencies' decision-making across time. Then Thomas will come in and say a little bit about law as code and how we can actually somehow code the law into various roles and functions that has to be undertaken also in legal practice. And then finally, I will be talking about the AI Act, which will address some of the more ethical issues in regards to how legal tech can be used. The AI Act, as you may know, is presented by the Commission, proposed by the Commission last year, and is still in the process of being amended and expected to come into force, I think, within a couple of years' time. So let me start by saying a little bit about some of the legal tech. And basically, as you know, development of legal tech is a new way of reading the law and analyzing the law. We come from a background of natural intelligence, which is an analogous or way to approach the law, reading texts out of books. Nowadays, you find, of course, texts also online in various legal information retrieval services, but often it's just a matter of being presented with various documents that you can search through this way. But rarely do you meet like these more intense computational analysis of these case law. And this is what these new artificial intelligence practices can be used for. And I have outlined here 3 new ways of reading the law. One of them is through network analysis, and I'm going to say a little bit about how that works in practice. Also machine learning and natural language processing. And then for the final one, code as law, I'm going to hand it over to Thomas, who will be elaborating more on this. So this is basically the transformation that we see with legal tech. These are new ways of handling and analyzing legal information. And let's start with network analysis. And just for those of you who haven't really worked with network analysis before, network is, as you know, in its simplest form, just a series of points that are connected to each other. These points can be various things. They can be human beings, for example, who are connected to each other in various ways, either because they work with similar things or because they are friends. And a network can then consist of friends and friends of friends and so on. So you can follow them through the network, a little bit like you see on platforms like Facebook and LinkedIn and so on. And network analysis has been used in many sciences, but it is actually new to use this technology in legal science. And for a legal application, the points in a network may consist of decisions or statutory provisions. And in the examples I'm going to use, it's going to consist of decisions from court of law. And these points can then be connected through references or common content. For example, the occurrence of certain words, or in the examples that I will be given, basically drawing on practice from the European Court of Human Rights and also from the Court of Justice of the European Union. These connections are made by the court themselves to refer back to previous cases, and these references are often used as a way of justifying a new decision by the court. So that way we can actually follow the case law back through time, and we can see how different cases are related to each other, because the court itself refers explicitly to its prior case law when it makes new decisions. And in that way, over time, we have built these very big networks. Another technology that we will be introducing here is machine learning. And machine learning basically consists of an algorithm which is trying to find similarities and differences between the individual data points in a data set. And these similarities and differences are then exploited subsequently to categorize new data. So here you can see a very simple example of what machine learning is. You have a training set over here. The training set is basically where you run the algorithm on it, machine learning algorithm, and then the machine learning algorithm finds various features from the individual objects in the data set, and it uses that as a way of categorizing the various objects into a number of groups. And then you have the test set below, and once the machine learning has come up with a model, then this model can be used to categorize new elements which will be coming in through the test set. And then it will automatically now categorize, in this case, the various fruits into various categories. And the same technique here, its example is used with fruits, but in law, the data set can be, for example, all the decisions from some administrative body or from a court, and the individual data points can then be the individual decisions, which of course are made up by a language. So the language will be what is determining the similarity of language between cases, will determine how these different cases are then categorized in various groups. And this is precisely what we know as natural language processing. It is machine learning applied to language. And there are a couple of examples here, which I'm sure that you know of already. Autocomplete, which you can see on this image. Would you like to grab some coffee with me in A? And then this autocomplete model that you have on your phone suggests 3 different words. And instead of writing out the word, you can simply press your preferred word, and then it will insert that automatically. So it builds from a predictive function compared to the one with the fruits. And here, if you have like this kind of sentence, then the model predicts what will be the next word. And of course, it can only do that if it has a lot of previous examples of how language looks like. This is how these predictive models are working. They build predictions from a lot of previous examples where they have found patterns in the language. And you see this technology used also by Google Translate, which I personally think today works remarkably well. And Google Translate helps to accelerate both quality and efficiency in translation across languages. Of course, for some languages, it works better than other. But for most of the languages that I'm familiar with, for example, French, the Nordic languages, Danish, Swedish, Norwegian, and English, it works remarkably well. For German as well, I think. Apple's Siri function is another version of that, where you just have spoken word instead of written word. And there are also examples of how this technology is used in law. For example, there's something which is called contract review, which is a model that has been built to review contracts for specific types of terms and conditions. It could be various things like business secrets. It can be things like competition clauses and so on in various contracts, where the model will make sure to find missing elements or find actual text in a contract which signals that the lawyer needs to pay attention. So also, again, it helps to read faster through documents and read for certain purposes. Now I'm going to show you this example of how network analysis can be used in legal practice. And this is from research I conducted a couple of years ago, where I was trying to see whether this network analysis could actually work in practice. And before I start showing you in more detail, I want to tell you that what the experiment was that we wanted to test we wanted to analyze the development of case law under Article 14 of the European Convention on Human Rights. There is almost 1,000 decisions that has been handed down by the court within this specific provision, Article 14, which is the prohibition of discrimination under the convention. And we know from the textbooks that are written by lawyers using the old method that they are usually, I mean, the way these various cases are grouped, they are grouped according to what kind of discrimination we're talking about. You know, whether it's gender discrimination or discrimination based on age, ethnic groups, nationality, and so on. And we wanted to see whether that was actually also true in the real case law. You know, whether cases were actually grouping, you know, linking to each other based on these various categories on discrimination. So we built this network. We subtracted all the decisions from HUDOC, which is a database which contains all the decisions from the European Court of Human Rights. And then we connected them also using the metadata from the same database, because the court itself publishes which decisions they cite in a given ruling. And it then allowed us to present this little film here. You can see, I just started running it now, and then you can see over time, more and more cases built, and as time goes, we have more and more decisions. These decisions refer back to previous decisions. And on this graphic, you can see the bigger circles are actually the decisions that are more cited. The smaller circles indicate that the cases are not cited very much. And the various colors here are the various clusters. So you can see that, for example, over to the left, you have a kind of yellow or dark yellow, brownish cluster. And they are all cases that cite each other more between them than, for example, the blue ones, which lay above. They again cite each other more between each other than they cite the dark yellow ones. And you can see another cluster of green at the bottom and so on. Some clusters are spread out a bit more, some are more dense and so on. And it all allows us to perform an analysis. So now what we thought was, these clusters then, do they actually fit onto the model that the lawyers have produced manually when writing up textbooks? So is it actually true that these various clusters, they map onto the different discrimination grounds, gender, age, and so on? And we found out that actually they didn't, but they were matching each other in another way. And now maybe it's a little bit technical, but Article 14, the prohibition on discrimination, is not a general prohibition on discrimination. It is Article 14 in the convention can only be used together with another article. So it can be discrimination within the field of freedom of expression, or it can be discrimination with regards to the right to a fair trial, or it can be discrimination with regards to right to privacy, for example. So the discrimination article can only be used together with another article, Article 10, for example, which is freedom of speech, or Article 11, which is freedom of assembly. And what we found was that these clusters, they actually matched much better these other articles. So what we could see was that these other articles, that was actually how the court was thinking of this case law. Not so much citing a previous gender case with a new gender case, but more citing a previous freedom of expression case with a new freedom of expression case, rather than going across these other elements. So it was quite remarkable, and it was a very interesting find, and we could then follow within these clusters how the case law had developed, and we could see another logic to the way that the court was thinking about this. Something that could be very useful also if you wanted to convince the court, for example, with a new type of argument in a new case. It also gave us evidence of what were the most cited decisions. And once again, if you want to convince a court of something, you might be better off citing something that the court itself has cited previously, because it may come across as being more convincing. So there are some nice applications to that. So this is an example of how we can use legal technology. Another example of this is a research I have not myself been part of, although I am now collaborating with some of the researchers from this project. It dates back from 2016. Using natural language processing, these researchers were able to predict with 79% accuracy the outcome of human rights cases. And I think this has been improved to an even higher level of accuracy nowadays with some of the new models that have been applied. And this could also be very useful because if you have a given case and you want to know what the likely outcome is, this can be, used as part of the information that you use when you decide whether you want actually to go to court with a given case or not. So for these considerations of whether it's worth spending what is usually quite a lot of money in going to court, this could be useful information. And it can also be used to find out what are the pros and cons. You can see what kind of information the model pick up, and then you can use maybe to tweak your arguments in order to make sure that you convince better, and then perhaps can win the case. So this could also be quite useful for litigants to have this technology at their availability. Now I'm going to move on to, as I said previously, I think Caitlin mentioned it in her introduction. We've also, me and a colleague from iCourts, we've also been working with a law firm. In Denmark, it's a law firm called Kammeradvokaten, who litigates for the state in various lawsuits. And this first case that we were involved in using our legal technology was a case on voting rights. And this is a case that arose because in Denmark, the Institute of Human Rights decided to sue the Danish state for violation of human rights. They argued that there were a group of citizens in Denmark who were not given the right to vote, and they were not given the right to vote because they were so-called incapacitated adults, meaning that they did not have any more their full autonomy. It was taken away from them for various reasons, usually based on mental illness, for various kinds of mental illnesses. And these people, according to the Danish constitution, do not have the right to vote. And the Institute of Human Rights decided to sue the Danish state, arguing that there should be a right to vote also for these people. And so Kammeradvokaten, who were litigating for the state, approached us. They had taken an interest in our technology and wanted to know a little bit about what it was and how it could be used. So we decided to collaborate with them, not because that we were particularly in favor of having to argue particularly their side of the case, but they were the ones who were willing to engage with us, and we thought it was important to try to see if our technologies also made sense in the real world. So we used two kind of legal technologies, if you like, or two kinds of arguments that we helped support this law firm with. There were two arguments. The first argument was that in this kind of cases, there is a high margin of appreciation, meaning that member states have a high level of discretion to decide where they should put the balance between the right to vote and the various limitations on this right to vote. Because it is clear from the convention that you can put limitations on the right to vote. And there are numerous cases about this. This one was about incapacitated adults, but there's also been numerous cases about the right of convicts, for example, to vote. A lot of cases has been on this in regards to the United Kingdom, where, for example, this is not allowed. So we argued based on this. You can see that on this slide, you can see the development in margin of appreciation cases, and in particular, you can see that margin cases rose quite sharply around 2010, allowing now for much higher margin of appreciation. And we could also show the kind of cases where this margin is particularly important. And we could show that therefore the Danish Supreme Court should rest assured that they had margin of appreciation to decide that it was okay for Denmark to decide that these particularly incapacitated adults should not have the right to vote. Furthermore, we also relied on network analysis in practice because we were trying to calculate the authority score of a number of cases within these fields. It's protocol number 1, article 3, and you can see here the 3 main cases that were used by the litigators. So the law firm that we worked for litigated the case mostly on Hearst, whereas the opponent, the Institute of Human Rights, were mostly relying on KISS and Scopola, which these are just names of judgments from the court. And you can see that Hearst is by far the leading case, and Hearst actually sets out also that there is this wide margin of appreciation, and it takes a lot to actually overturn it. And the case that spoke most in favor of the opposite view, namely the KISS case from Hungary, I think, which was a much broader limitation on the right to vote, and we thought that it did not apply. And here you can see from the Supreme Court ruling, this is precisely the arguments that we also help to support with our various technologies. They ruled that there is a broad margin of appreciation within this area, and they precisely also, the Supreme Court now also cited Hearst for that. And they also cited, of course, they had to relate also to the counter arguments, and they also highlighted here that Aldeios Kiss, the Kiss case, is the only verdict from the European Court of Human Rights where a right not to vote was where the case was lost, and that this was on very specific, related to very specific and very broad, wide-ranging limitations in Hungary. So the case was won by the Danish state in this case. We're not sure to which extent our technology was part of winning the case, but we can see that we managed to support with this technology and the information that retrieved from the court, the arguments that was put forward also in a more manual way by the court. Then in another case, we used also the same network analysis. This time we worked with this law firm in a slightly different way. They came to us with a case that they had already identified as being relevant, this time this Kühne case. We wanted to see whether we could help them find other cases that they could use to support their arguments. And you have to remember here that these lawyers, they are paid quite a high salary, 2,000 Danish kroners per hour usually, to sit manually and look through, various legal information systems in order to see whether they can find cases. So if this could be done, more efficiently, that would be worth quite a lot. And here we managed to find, and I'm no expert on EU law at all, but we managed to find a couple of cases. Some of them they had found themselves, some of them they considered to be irrelevant, but we also found this Arcor case. And again, they included it in the arguments, and again it was cited by the Supreme Court in their ruling. So we thought that was really nice, that some of the instruments that we have used could actually, to some extent, add value to what could be done by lawyers using more traditional legal methods. So this was fun. I think this was definitely the first 20 minutes. And now Thomas will come up with some other examples of legal tech. So now I will stop sharing and allow Thomas to share, so we can see some other approaches to legal technology, this time I think more towards law as code. And I will go on mute while Thomas speaks.
Thank you, Henrik. So I will continue and talk about our work on law as code and the use of it for legal decision making. And yeah, as already said, I'm professor at the Department of Computer Science at the University of Copenhagen. And besides being PI for research projects on AI and digitalization of law and workflows, I have also been member of the Danish Standards Group for AI and cybersecurity, and also the new marking that has been made in Denmark for allowing companies to get an approval of dealing responsible with data, and so they can get this D seal. So yeah, and then I have been doing a number of projects. Two of the projects down here are actually in collaboration with the Faculty of Law. So I have the project on public administration and computational transparency and algorithms jointly with Henrik. But I will mostly talk about work we did in a big project funded by the Innovation Fund in Denmark called Effective, Co-Created and Compliant Adaptive Case Management for Knowledge Workers. And basically, I will tell you about what we have been doing there. So the research section briefly works on the bridging between development of software systems and people. And this is crucial to get a dependable use of IT systems, we believe. And the point of digitalizing law and making law as code is to support making the right decisions, which is required to have a sustainable development. And also to get a more equal and fair access to the law, so people can understand their rights, and also that the government institutions can support citizens in a fair way. And the project started out with the reports in Denmark stating that actually in the municipalities, when the appeals agency made an analysis of practice, they discovered that more than half of the cases they looked at was actually incorrect according to the law. And this is a pattern that repeats and repeats. And as late as yesterday, there was a radio interview saying that at the area for people with disabilities, there are more than 1/3 of the cases that end up in appeals and actually get changed because there was an error. And this is a very critical domain, because if you have a disability and you apply for support, you cannot wait a year to get this support. So that's a really key problem. And that's, of course, not helped by the fact that the municipalities get an increasing caseload, and also that they're using old IT systems that actually do not know anything about the law. So there are no support for actually following the law built into the IT systems, or very little at least. And the problem with law is that we have so many laws on a national level and on European level, and there are also now guidelines for how we should use AI and personal data. And they are manually interpreted today in many different ways, depending on the reader. And that makes it very inefficient and very error-prone. So one may think that, I mean, we can just make digital processes, implement legal processes, and then use business process automation. And that is kind of an old dream, at least 50 years old, where people have been drawing processes that they believe follow the law, and then implemented that in IT systems. And now we also have standards for drawing these processes. We have standards for decision rules. We have then also tried to make these neural networks and AI to help us make the decisions according to the rules. But the problem is that this doesn't really work in practice. So when we try to implement these processes, we get a very rigid way of interpreting the law. And that might fit for 70% of the people, but then we're actually hurting 30% of the people that needs more flexibility than using this fixed process. And also, the process doesn't really contain directly linked to the law, so it's very difficult to maintain it when the law is changing. And we see today that even in the finance sector, where they have a lot of money, that's kind of their business, they spend so many money in Denmark, but also in other countries in Europe, that it corresponds to 1/10, every 10 employee is actually working on compliance, and they still get complaints. So we need to move from this idea that we can automate a standard route, like the highway, which is kind of the assembly line when we produce cars, to model and implement the legal rules, like the map that when we are driving in the car. And this is what we have been developing. So that is a rule-based AI for helping people navigating in the law. And when we have that, we can also get a much more precise map of where we're actually driving when we are following the law. So we can start using AI to also learn from what are the most complicated parts of the law, and maybe the places where we could try to simplify or help the caseworkers and citizens even more. So there are several attempts around the world on working on this digitalization and law. And in Denmark, they have mostly been interested in trying to simplify the law so it can be digitalized with standard technologies. While in other areas, people also actually think that, well, we may actually try to handle the complexity in the law and make a digital model of the rules, and then not try to simplify the law unreasonable. Because there's a reason why the law is complex. It's because the world is complex. So we will never reach the final goal if you only think we can simplify the law so much so we can put it into a standard computer program. So what we did was that we, in this 4-year project, jointly with municipalities, jointly with the state authority in Denmark and interest organizations and companies, we developed tools that allow to make highlights of the law, activities, rules and roles, and put them into a digital rule-based model that can directly be used to support caseworkers, but also citizens in understanding and navigating the law. And we did that by covering kind of in a multidisciplinary way, studying people, how do they actually work in municipalities doing casework, which decisions can be made digital as part of the law, which should not be made digital because they are actually a discretionary decision that should not be made a rule. And then we looked at these tools for co-creating models of the law, so we can actually have the domain experts doing these models of the law and the lawyers. And then we looked at how understandable these models are when you look at them with eye tracking technology. And finally, we looked into how could these models then be used to help navigate and improve the casework. So one thing we discovered when we actually interacted with the caseworkers and followed them was that often people come with technology and try to solve a politically motivated problem. That could be predicting the future of the citizen. I mean, is this a citizen that needs special care? Is this a citizen that's going to be unemployed for a long time? But this is actually not the need of the caseworker. The caseworker, they can actually see this themselves pretty well, but they really need tools that can help navigate the law and understand this complex process. What is it that makes it complex? So it helped us moving the perspective from predicting, profiling citizens to actually understanding the complexity of the casework. And we built on 10 years of research and more than 40 peer-reviewed papers on making digital models of the law, jointly with a company that was then founded in the project called DCR Solutions. And the whole idea is to capture the rules and not the flows, because then we can support people doing the right flow with much more flexibility. And that gives us one model of the law with many usages. And actually, we also looked into NLP text processing technology, so we could help annotating the law with activities and roles and actions. And that is something that can keep on being improved as we get better and better language models. But it cannot be fully automated. We need lawyers, domain experts to validate that this is actually the right markup. And then it can be used in this tool where we get the rules to simulate, is this really our understanding of the law, and then update the digital model, which can then be exposed to users either as dynamic guidelines showing these are the standard rules, or give them a decision tool for navigating before, just to understand the law, or they can be embedded into the case management tools. So we have embedded in big tools from NEC called the Workzone, which is sold around the world, and gives a checklist so you can be reminded of deadlines. And then you can analyze what actually happened, and then use this to simplify or to highlight some rules that are complicated to understand. And finally, we contributed in the Danish standards work, providing a specification on how to involve users from the idea to the implementation to the use of an AI-based system for decision support, while we are waiting for standards. So if you zoom in, here's a small paragraph from the Danish law on social services called duty of notification, So this is a duty that a citizen or a school has to report if they believe a child is being mistreated at home. And it's also an area where it's very crucial not to make mistakes, and mistakes are made all the time. And the tool allows to visualize this model with preconditions and responses, and you can simulate it and get a checklist, and then you can step through receiving a notification, acknowledging a receipt, and see the swim lane of this process. You can also model web forms with the data input. And this is just assuming in that we also did this study then of how well do caseworkers and lawyers understand these models, and where do they look in order to understand and answer questions into these models. So to give a concrete example, we took a GDPR decision tree, which was ambiguous and difficult to use at the university, Copenhagen University. And then we made this digital model, which looks a lot like the tree, but now it's actually formal, and you can follow what people are doing, and they can get an online tool where they can step through these processes directly made from the model. And if you find out that you need to update the model, that's just 2 clicks. So the conclusion here is that if you want a sustainable development, it actually requires that we can make the right decisions in compliance with the law. And our legislation is increasingly complex. And we cannot just rely on simplifying the law, because the world is complex. So we need to handle this complexity. So we should not believe we can make everyone drive on the highway. So in this project, we actually develop now mature tools that can use to develop transparent rule-based AI solutions to make a digital model of the law. And this can then help to give a more fair treatment by the public authorities, and also help how should we then simplify the law. And this, we believe, we now have clear signs that is provide a more ethical and more valuable use of AI than any of these attempts to predict the future of the citizen, because it's difficult to find out if we predicted the right future of the citizen, while it's very easy to see if we provided the right objective rules of the law. So that was what I had taken. So I will give the word back to Henrik.
Thank you, Thomas. And I will share again. Just to sum up then, just to say a little bit about where we are now then. As you can see in my presentation, first I spoke a lot about case law and how various technologies can be used to model and leverage information from past cases, whereas Thomas was talking more about how you can model legislation. So these are 2 different approaches, which obviously could be combined and be used simultaneously, because it is almost always the case that whenever you make a decision in law, you rely both on relevant legislative texts which has been enacted, which are formally valid and which must be applied, but you also rely on previous decisions made in accordance with this legislative text. So these 2 approaches actually combine and supplement each other. So now we are coming a lot closer to discussing some of the themes that fall under legal tech and ethics. I'm going to talk about the Artificial Intelligence Act that was proposed last year by the European Commission. And the Artificial Intelligence Act is, of course, itself a piece of legislation, but it's worth remembering that a lot of work went before that, and a lot of ethical considerations have been made which are underlying this proposal. So the proposal itself actually is in some ways the result of ethical collective reasoning orchestrated by the Commission in the run-up towards this act, and should, I think, reflect in some ways a kind of I don't know, reflective equilibrium, if you like, a kind of a balancing of various interests and ethical considerations. It's worth remembering that this proposal came out, as I said, last year in April by the Commission, and now there's a 2-year procedure where the European Parliament and the European Council are deliberating on this proposal. The Council already came out with a report which was quite positive towards the proposal. There were only minor amendments, and it is now pending in front of the European Parliament. And it is also worth noting that application of this regulation will only come into force will only be applied only 24 months after entry into force. So there will be a 2-year adaptation process so that companies and public authorities can prepare themselves for this new regulation. And the aim of this regulation is to introduce harmonized rules for AI systems on the internal market within the European Union. That is where the European Union gets its legal basis for introducing this kind of regulation. It's internal, the internal market, so that AI systems can be used all over Europe. And it would, of course, be quite counterproductive to the development of such systems if they had to be approved in each member state. And there is a prohibition on certain artificial intelligence practices. I shall come back to that. Then there are specific requirements for high-risk AI systems with obligations for operators of such systems, and I shall also say a little bit about that. Then for lower risk systems, there are to some extent some transparency rules for AI systems that are intended to interact with natural persons. I shall not be saying anything about this really because it's considered to be low risk. And then there are some rules on market monitoring and surveillance, which I shall also say a little bit about because I think it's important as it shows how these rules are actually being enforced. So first of all, it's important to highlight here that there are certain roles in this act which sets out the various requirements under the act. The act speaks to those people or companies, or institutions that develop AI systems or that has AI systems developed for them with a view to placing it on the market or putting it into service for some kind of operation, either under its own name, under its own trademark, or whether it is for payment or even free of charge. In those cases, the act will also apply. So this means that the AI Act doesn't actually introduce any new rights for citizens. The protection of citizens is supposed to take place through the regulation of the providers and the distributors and the importers and the users by placing certain burdens and requirements on them. The outcome should be a better protection of the citizens, but the citizens themselves are not addressed by this AI Act. What is artificial intelligence for the purposes of the AI Act? There are mentioned here 3 types of technologies that are considered to be artificial intelligence. Machine learning is one of them. I've already introduced that a little bit in my first talk. Logic and knowledge-based approaches, which are similar to the ones that Thomas was talking about in his talk. And finally, there are also these statistical approaches, search and optimization methods, etc., which are similar to the ones I also mentioned in my first talk under network analysis. A lot of this is based on optimization methods in searches and very statistical approaches, measuring how popular or central a given case is, for example, in a set of cases. So these are the three kinds of techniques, and as you can see, some of it is really basic, kind of these statistical approaches, which are kind of basic mathematical operations. So there's a pretty low bar for calling something artificial intelligence in the act itself, which I think makes sense, because what is most important and what is the focus of regulation is actually the risks of using these methods in specific kinds of contexts. And I should come back to what those contexts are, because there is quite clearly a way of determining whether something is high risk or not. But the main structure of the regulation is that it's a risk-based approach, and it sets out 4 levels of risk. At first, there is unacceptable risk, and in Article 5, you will find examples of uses of artificial intelligence which is considered to be unacceptable and which is therefore being prohibited with the introduction of this act. Most of the AI Act is about the regulation of high-risk artificial intelligence. And high-risk artificial intelligence will continue to be allowed. It will not be prohibited. But when artificial intelligence is used in these high-risk domains, then there are certain requirements that must be fulfilled for artificial intelligence to be used in this context. Then there are limited risk area where there is this requirement of transparency if you are interacting with an artificial intelligence system, a robot, say. And then there are minimal risks that are not addressed with this regulation. So first, the unacceptable artificial intelligence. Here's a couple of examples from Article 5. It's a very long article, so there are several examples. But here I just summed up what I consider to be perhaps the most important ones. Any use of artificial intelligence which can cause mental or physical harm by the manipulation of weak persons are considered to be unacceptable and therefore prohibited. These are AI models that typically identify and exploit weaknesses in persons, children, people with mental handicap, elderly people, perhaps with senility problems and things like that. Secondly, there is also a prohibition on assessment or classification of the credibility of physical persons by public authorities. This is, I think, what we have seen being developed in China with these social credibility scores that are being used there. This is now being prohibited with the AI Act for Europe. And also this use of systems for remote biometric identification in real time in public space with a view to law enforcement. This will typically be the use of facial recognition in order to be able to capture criminals. And the ban here is for what I would call full-scale, full-time supervision. So kind of the totalitarian use of these techniques are prohibited. But there are certain exceptions, and remote biometric identification in real time can be used for certain purposes on some locations at some given times, especially if police are on the lookout for very dangerous criminals, etc., and they have suspicion of whereabouts, then they might activate these remote biometric identification systems, also with the use of facial recognition, because it serves the purpose of trying to capture very dangerous criminals and thereby protecting the public. But there are limitations, and these are set as to when and how it can be used, and this is what is set out in Article 5. Then these high-risk systems, here there are actually two ways into it. So one kind of high-risk systems speaks about security functions in products. So things like cable cars, elevators, various kinds of toys that are sold to children, which have built-in safety systems, and some of these are considered to be high risk if AI is used as a security mechanism for these kinds of products. Could also be self-driving vehicles, etc. And then there's another way into high risk, which is an appendix to the Act, and here they have listed examples of what are considered to be high-risk AI systems. And in here you also find legal tech, which is what we are talking about today. Legal tech can of course be many different things, that it can be applied in many different contexts. But if we look at this list, and let's just start from the bottom, administration of justice obviously is where legal tech could be applied. And is applied some places around the world. There are some pretty horrific examples of this in the US. We can also come back to that during the discussion if you think that is interesting. But the administration of justice is considered high risk. Law enforcement in general, also high risk. Things like migration, asylum, and border control management. This could also to some extent be considered legal tech, because migration and border control are also under legal regulation, and therefore also legal tech could be used in these areas. Similarly, access to and enjoyment of essential private services and public services and benefits, right to social welfare, right to hospitalization, medical treatment, and so on falls under this category. And these are also regulated. Social welfare service legislation is a large part of what public administration is about. So also here, legal tech will play a role increasingly. It's already used. It will come out more, but this is now also being captured by this new AI Act. So I think it's really interesting that many of these areas, which are really important, are now coming under regulation. And let's see what kind of regulation. So what are the requirements for using high-risk artificial intelligence? And the requirements are listed here on this slide. You can see I grouped them here according to various articles in the Act. There's a requirement to have a risk management system connected to the AI system. And it means basically that if you use an AI system in this context, you have to have an idea of what kind of risks are associated with using it. In other words, you need to visualize what could possibly go wrong. And if those things go wrong, how will you handle these errors? You also need a policy for data and data governance. So you need documentation of what data you have used, including training data and test data. And you need to have a policy for how you govern your data, both the data that is behind the models that you use, but also how you treat new data. And remember that the GDPR also, of course, still applies here. Technical documentation. How have you trained the algorithm? If you use, for example, machine learning, how have you trained your model? And what kind of results did come out of this training, and how have you implemented the model in the software? Record keeping, keeping trace of the use of the model continuously, so that you can always go back and identify where things went wrong. So you need log files to have an overview of all operations in the system. Article 13 is particularly interesting, I think, because it highlights the need for transparency. It means basically that those people, human beings who operate the system, must be able to understand and interpret how the system works. There's also a requirement in Article 14 of human oversight, which ensures that high-risk AI cannot be fully automated. There must always be a possibility of human intervention in these systems. And finally, there are certain requirements in regards to accuracy, robustness, and cybersecurity, protection of the system against hacking, and so on. And for all of these requirements, it is foreseen by the European Commission that there will be an elaboration of standards through the European standardization system. So while these various requirements are described in the Act, there is a need for high level of documentation and a high level of precision in these prescriptions. And it is foreseen that this will come about through the use of standards that will be elaborated, as I said, in this European standardization system. And both Thomas and I are a member of Danish Standard, which is member of this European Standardization Organization, and we can confirm that the work has already started in this context. Here are some examples just for illustration. What does the text look like in the Act? So, for example, on Article 10, training, validation, and testing datasets shall be relevant. They should be representative, free of errors, and they must also be complete. And of course, standardization procedure would involve trying to describe what those 4 words mean more specifically in relation to datasets. Also from Article 13, high-risk AI systems shall be designed and developed in such a way to ensure that their operation is sufficiently transparent to enable users to interpret the system's output and use it appropriately. And again, more detail is needed in terms of what it means to be interpretable. What kind of ways would there be to interpret the system's output given the artificial intelligence technology that is behind, and what does it mean to use it appropriately? And then Article 15, high-risk AI systems that continue to learn after being placed on the market or put into service shall be developed in such a way to ensure that possibly biased outputs due to outputs used as an input for future operations, that is what we know as feedback loops, are duly addressed with appropriate mitigation measures. So again, I mean, a lot of care, I think, have been taken into addressing some of the most pressing ethical issues and actually putting them into effect through this AI Act. And finally, my final slide, and then we can go on to talk about and discuss various issues that you might want to bring up. Here, regulatory oversight and control are done through, there are compliance requirements for the various roles in Article 24 to 29. So developers and users and so on must be able to show compliance with the requirements for high-risk AI. This is done through various conformity assessments, and there is also an introduction of a certification system which is supposed to ensure that those who use these systems can show that their system does fulfill the various requirements because it has been certified. And there is a system of public authorities which are supposed to ensure and oversee that these certificates are actually only issued when there is a demonstration that the conformity assessment has been conducted correctly. So in that sense, there has been envisioned a kind of oversight and control system, and violation of these rules are also fined with very high fines. I mean, several million euros in fines for not complying with these rules. So ultimately, I mean, very high fines could be handed out for violation. So there's also this kind of support for the rules, and which again is a support, of course, for ethical and safe use of artificial intelligence in these areas. That was all for me for now, and I will stop share and hand it back to you, Caitlin.
Thank you both for super informative presentations there. Everyone, please feel free to submit some questions to the chat or use the raise your hand function if you'd like to ask a question. I'll jump right in with Christian since he's there. Let me put you off on mute. How do I unmute you? Ask to unmute. There you go.
Hi, my name is Christian Jeffal. I'm professor for law science and technology, and thank you so much for these I shall say four or five very rich inputs. So it was really interesting to listen to you and to see the different areas in which AI makes a big, or can make, or already makes a big impact on the law. So thank you very much for that. The question that was kind of in my mind with many of the legal tech issues you raised is, how do we unlock the potential to do new things in the law? And what would this actually mean? Because I feel, and I would include myself in that, I feel that at the moment we are very much focused on the legal practice as it is. But I think the methods you showed us would maybe also give us the opportunity to think the law new, to think it fresh. So not to reconstruct the practice, but actually to change it. And maybe to adapt this question a little bit to your presentations, Professor Hildebrandt, are we running into a complexity trap if we continue in that way? So this would be kind of a sub-question. And you know, in Germany, for example, we have big problems with tax law because there is layers and layers of tax law. I think it's now over 75,000 laws. You need a whole library if you want to print out all German tax laws. And algorithmization actually helped the authorities to even make it more complex, because now they can include risk management systems and they don't have to have it all by manual workers. So where do we stop with legal complexity, and are we not running a risk to do that? And Professor Olsen, I was really interested where you think the potential of network analysis lie to rethink the law. Because if I think critically about the very first example you gave, I actually like that textbook authors take a different stance than the cases, because I think they can reveal new links in the law, and the networks you showed might be due to several also down-to-earth reasons. For example, that when you look at the jurisdiction, the parts of the court that deal with specific articles, so not Article 14, also deal with Article 14 questions. So they also cite their own legislation. And I completely agree that you make a better case when you present the judges kind of their judgments. But maybe it would be also interesting to look from your perspective for new relationships that not only reconstruct of how the court works. So I'd be just amazed to hear about where you see the potential for actually also rethinking the law. And I try to specify this with two sub questions. Thank you very much for this wonderful presentation.
Thank you very much, Christian, for these questions. I mean, you're completely right. I mean, we have this increasing complexity, and could the IT technology then just help us make it even more complex? But actually, what I believe, and also why Henrik and I are now also approaching the next step, namely engaging with the lawmakers, is that this could be tools that could help us also clean up the law. Because if we mark up the law digitally when we make it, then we could also support the lawmaking process and actually address the problem at the root, namely that when we make laws, we just add on. By having these models, we can actually also analyze for where the complexity is. And then we could start supporting a new way of making laws, namely feeding back how are the laws used. And then that could be a live feed of understanding problems in the law. Because right now, when you adjust the unemployment law in Denmark, for instance, it's kind of after the fact. You get a very small view of what is happening out there, and then you try to put in some laws for different reasons, and then you wait for 2 years to see if it worked. But this might actually give a much more direct feedback. So I'll give the word to Henrik.
Yeah, I also want to thank you for a very, very good question. I think it's really interesting. I'll do my best to try to answer it. It's not an easy one, but I will start by saying that I think the way the law evolves even today is in a kind of hermeneutic way. There is a close relationship between legal practice and legal scholarship. Legal scholarship addresses legal practice and absorbs case law in various ways. Then they process this in various ways. They usually try to go for some kind of rational reconstruction where they build a kind of coherent image of what the law is. And those textbooks and other articles are then in return absorbed in legal practice by the judges. So there is a kind of like a close connection between legal scholars who work in a doctrinal manner and then these courts. So this also means that often there's only very little scope for this kind of refreshing or new take on what the law is. What I think is the advantage of these new technologies is that not only can they serve this, I would say, instrumental purpose that I also discussed in my presentation, but they can also serve as a way of uprooting existing narratives, because they can show a much larger picture of what is happening in the case law. Often with textbooks authors, there's a funny agreement between them about what kind of cases they consider be relevant, but many cases are never really talked about. They choose cases that they consider to be relevant, but many more cases are out there. And what these models can do, machine learning and so on, is that they can pick up biases, they can pick up eruptions and find other kinds of patterns in the case law that traditionally, textbook authors cannot see for themselves, because they cannot process the same amount of information, and they can certainly not process it in these new ways that machine learning can do. So you can actually arrive at more creative understandings of the law by using these technologies. But we're not at this stage yet. I think we are still at a stage where we try at least to make these models meaningful within the existing context and trying to make them useful and comprehensible. And I think once we have seen a little bit more uptake of these models, can we start to move to the next level, which is to play a little bit more with it in a creative way. So this is my way of trying to answer your question. And thank you very much. I think it's a very interesting question.
Thank you, Christian. We have a lot of questions in the chat, so I'll jump over there and then back to our raised hand. One of the questions goes back to the first presentation with this example of the predicting the outcomes of cases in the case of human rights law. And you can imagine there's a lot of positive implications of that, especially when you're talking about maybe public sector with low, where there's a lot of not enough capacity to handle all cases. How do we make the most of our time? But this person is asking, do you think it's possible so these type of predictive tools might impact the sector to a point where some people will pretty much be either outpriced or just shut out of legal representation, right? Because the predictive tool and what we're often worried about with AI is a certain group might be disenfranchised by such a predictive tool if there's race elements in there or gender elements or other groups we can maybe think of. Is this a concern or something that's being talked about in the case of these predictive tools?
Yeah, thank you for this question. Also very relevant. I think that the situation we have today is that trying to present a good case and going to Strasbourg with it is very expensive. And I think that those who will actually benefit most for these models, if they're put to use, at least to start with, would be various NGOs who on a like voluntary basis, mostly not without many resources available to them, could actually have very much use of these models in order to help them to present better cases. But there is, of course, this worry that the new technology would simply be another new arms race, if you like. The more money you have, the better technology you can buy and the better you can make use of it. So I think it is a legitimate concern. How to address that, I'm not really sure. I mean, I don't think we can put a ban on, using this new technology. I don't think it's the way forward. I think the way forward is really for us researchers, for example, I mean, to engage with NGOs and try to get those models to work in order to lift their capacities and their resources. I think that is the best way forward. I don't know if it's the best possible answer. I don't know if you have a better take on this, Thomas. It is a difficult one, but I really think that it could really help today many NGOs with scarce resources to produce better quality and more efficient drafts of complaints.
Yeah, so what we are trying in our research section is to engage with the public authorities in auditing what they're doing, and then also working towards having open accessible tools. So it's not a paid for service, but actually an open democratic access to the technology. But of course, that requires that public funding goes in, because there are not that many private companies that will just make an expensive service available for everyone.
I would also like to say that I also only work with open source, open access, and so on. So it's for everyone to use.
Yeah. We have another hand up. If Leo's still there, you're welcome to unmute yourself. Yeah.
So I was kind of thinking about asking about the AI Act. And very often people say that it is a risk-based system, but if you look at the system now, there is no risk assessment included in the high risk definitions. There's a definition what sectors are high risk. It is actually a sectorial regulation figuring out that certain sectors are by definition high risk. For example, taking education, then they say that if you are high risk, for example, in education domain, it says that whatever you do in that range, in that domain, you don't assess the risk, but you have to build a risk assessment system. This means that people who are grading essays, for example, by giving points to people, and they are using statistical methods like calculating the average of multiple questions, is actually an action that is defined to being AI, and it is actually also making the system high risk. So it means that every time when every kind of a professional kind of teachers are using a tool, let's say in Excel, to calculate the average of the points, then they should actually have all the documentations, all the transparency actions, all the knowledge management systems in the way. And even then you are not assessing whether the system is risky or not. You just have to have a risk assessment system there. And when you have that, then you are conforming with the regulation. So it is not a legislation that defines a risk and figures out what you should do. It's sectorial regulation for certain, mainly public functions that was doing. So I have been looking at the standardization of these functions and how you define the standards, because they are definition from standards or technical standards, what is defined by risk. But any of these kind of components are not making the system risk-based in the way that you would technically being able to easily assess it. So whether you have any comments on that, it would be nice to know.
Yeah, so as I understand your comment, you're saying that in some sense the definition of risk is too broad in the Act. Because once it highlights that anything which has to do with education is high risk, then it captures anything, even the calculation of an average score for students on some course. So it is too broad simply, and thereby it might become inefficient. Is that what you are getting at? It's just to be able to clarify what your comment is about. I agree that it is.
Yes, I was unmuted. So my question was in that. So if we would specify more what in education creates the risk. So whether it is, for example, using AI to grade essays themselves. So
Sure.
then they may be some political kind of, let's say, agendas in the risk that would actually be make it so that that they would really risk on pushing a certain kind of opinion through to people and having that kind of a, let's say, solidify opinions and grade people according to their views. So that could happen, for example, which I think a real risk in what would be in education, for example, if you are grading something. But the definition is not defining the high risk Annex 3 areas in such a way that just define them as sectors. So I think that could be solved by making the Annex 3 more definite and kind of a more specific about what are the dangers one is expecting that could happen, and then one could be able to figure out a little about this risk-based analysis on that.
Yeah,
Yes.
I think the problem with a more fine-grained approach is that it will probably be very difficult to reach agreement on exactly what kind of procedures and actions within those domains should be considered to be high risk or not high risk. You know, so this more granular definition of high risk, I think, would meet with a large amount of difficulties in reaching the necessary political compromise for making sure that the act can actually go through. And I think that is the main problem behind it. So that's why the regulators here have decided to go with this broad-based approach, and then trying to fill out the more specific meanings through this standardization approach. And so this way you could easily go about the problems that you encounter there, because these standards are more easily upgraded subsequently. So
Yeah,
I think
we're
that's
also,
Thomas.
yeah, I mean, now we are sitting in the Danish standard, which is also leading the Secretariat for the standardization efforts in European Union, and I think this is the balance, right? Because by requiring everyone to consider risk if they are using this technology or any kind of technology, because it's a very broad definition in the education or in police or social services, that can then be addressed in the standard. Then if it's a trivial risk management system, then hopefully, because I mean, we have also companies and people who are interested in having manageable procedures sitting in these organizations, then that will be addressed in the standardization efforts. That then it's actually also trivial to have a risk management system for that. And of course, yes, it may say right now that you just need to have the risk management system. I guess it's implicit, and then you are also actually going to use it and react on whatever comes out of using the risk management system. So I'm on the positive side. Of course, every regulation can turn out to have stupid side effects, and then it needs to be corrected. I mean, we're all saying yes to cookies every day, right? And it's debatable whether that is really helping. But I believe that the division between having a very high-level general regulation and then having the standards as the operational implementation of this is a possible good way out of this problem.
Thanks. We have another question that related one I had as well in the chat, and that has to do related to this Article 13.1 that you talked about, with the need for transparency and interpretability. Often we say explainability. I was wondering if, on my end, if there were good examples that you could think of or that you've seen where explainability or this interpretability is vital in kind of technology being used in the legal sector. On the other hand, someone asked, often the more complex models get, the less interpretable or explainable they are. Do you find this also to be a challenge, particularly from the examples that you've been talking about? How can it be addressed? Why or why not are you seeing this explainability kind of challenge?
Yeah, I mean, so that was part of the motivation why we took this rule-based approach, and actually made a lot of efforts and actually also studying the understandability and the traceability, because I think if you use a tool to help notifying you what you should do according to the law, it's very important that non-experts can trace if this is the right implementation. So here, explainability and transparency is crucial, because many of the errors we have seen in also in the Danish public sector in IT systems is when the law has been coded in non-transparent, opaque code. So definitely this is an example. On the other hand, if you have something where it's immediate to see if the answer is going in the right direction without knowing how you came to the answer, recognizing numbers, and then you can compare that it did the right number model. Then it's not so important to know exactly how it recognizes these numbers, because you can verify it easily. So in that case, in these cases, it's not so important.
I just wanted to add to that I mean, for decisions in law, whether they are taken by courts or public authorities, there is a requirement, I think, in all European countries that these decisions must be followed by justifications in the form of setting out the reasons for why the decision was the way it was. So the decisions must be able to clearly state, what are those facts in your case that combined with the law interpreted in whatever way it is interpreted that led to this specific result. So there is a burden of explanation on public authorities and courts vis-a-vis the citizens, and that's very important. And I think that also means that you can't really use like fully automated models based on machine learning to make decisions. That would be not only illegal under this new AI Act, but it would also be highly unethical. You need to be able to produce genuine reasons for the decisions. So of course, these decisions can be partly generated by AI models, in a sense that a caseworker, for example, might not be able to fully see 10,000 decisions that have been made previously, and may rely on AI to find decisions that are relevant and retrieving out of this huge amount of data previous decisions that can validly be part of an explanation to a citizen. We've previously decided this case in this way, and we've previously used this decision. Now your facts are not dissimilar from the facts of the previous case. In fact, they're quite similar, and therefore we decide your case in the same way as we decided the previous case. So these kinds of things, but you must be able to, and here the explanation is that the transparency here is that we actually have a practice in our institution. And the AI models has helped us identify that decision tradition, if you like. So I think that's.
Thanks. I think we're running out of time, and there's a couple questions that are just along the same line. So I'll try to sum them up as the last question of moving kind of from policy to practice. So the one question asked about the AI Act and that it's often argued that it's not specific enough. It needs to be, it's going to be difficult to transfer to practical concepts. What is an approach kind of to this? Similarly, someone asked about the standards and standardization projects you're working on, and how do you actually turn these standardizations into a part of the law? So moving this kind of policy to practice, what are some of the challenges and approaches you've taken?
Well, this standardization approach is actually set out in the AI Act itself. So the AI Act, in some sense, turns those standards into law, and they also become an industry standard. Just like we know from various other kinds of products. It is like the AI Act is a form of product regulation. It treats artificial intelligence systems as products and regulates them according to the same way that other products have been regulated. So these security standards are very much being developed in a collaboration. I mean, these standardization organizations there, they have both industry members and they also have members from governments and researchers. And it is a collaboration between, you know, these kinds of agents, industrial partners who know what is possible and feasible and how these products are being designed and produced. Governments who have an interest in making sure that regulation is sufficiently tight and that these standards can also be used, as in this case, to make sure that it's possible to actually fulfill whatever requirements there is under administrative law. And then researchers like Thomas and myself who come in with you know, like a more idealistic view, or, you know, based on a broader perspective. Do you want to add to that, Thomas?
I think it summarizes pretty well. So we are contributing to these standards and making sure that they are actually kind of a balance between the idealism and what is practical, and then also just doing the oversight. So it can also be transparent how the standards are being developed. Because before I entered this group, it was not really transparent to me how standards are being developed. So I think this is also an area where transparency can be brought in.
Thank you both so much. This has been really great talk, and we're unfortunately out of time. I want to take a final moment to let everyone in the audience also know about our next speaker events. We'll have Dr. Tokomaru on April 7th. That'll be our first back to in-person event on the TUM campus. We'll also have another virtual speaker series on May 12th with Manuel Herranz from the UNICEF Office of Innovation. And our last speaker series for the spring summer will be on the 21st of June, also in person on the TUM campus with our visiting professor Aditya Yori from George Mason University. You can register for all these events on the IEAI webpage. And I would like you also to remember to the best way to keep up with our events and our activities is to visit our webpage, subscribe to our newsletter, and follow us on LinkedIn and Twitter.